Hi, and welcome to today's webinar on the Data Use and Access Act, what it means for your organization. I'm Naomi Grossman, Compliance Manager here at VinciWorks, and I'm really looking forward to unpacking the Act, especially because it's one of the most important new shifts in the UK's data landscape. Why is that? This Act isn't just another piece of legislation. It's really reshaping how organizations can share, access, and make use of data, while at the same time tightening the guardrails around privacy and accountability. For organizations, it could open doors to new opportunities, but of course, also raise fresh compliance challenges. That is, if your work touches data, and whose doesn't these days. Understanding the Act is critical, and today we're going to walk you through what's changing, why it matters, and what you need to do to stay ahead of the curve. So remember we really do want to hear from you during today's webinar. So if you have any questions or comments or any experience of some of these issues, please do let us know in the chat or in the Q&A, and we'll try to respond to some of those as we go through. If we don't get to your question over the next hour, we will get back to you by email. And you can, again, use the chat function, use the Q&A. We want to hear from you. The session, as I said, is being recorded, and you will get a recording immediately after the webinar. If you would like to see more VinciWorks training options around the Data Use and Access Act, or DUAA, you can write data into the webinar chat now. If you're interested in learning more about our GDPR registers, which can really aid in DUAA compliance, write OmniTrack now in the chat, and someone will be in touch. Okay, let's get started. I am delighted to be joined today by Nick Henderson-Mayo, VinciWorks regulatory and compliance expert. Welcome, Nick.
Thank you, Naomi. Great to be here, especially now with so much activity around the new Act. There's a lot for us to look through today.
So true. And we're also joined today by Alyssa Retson, head of courses at VinciWorks. Alyssa, I know you have a lot to say today on this topic.
Thanks, Naomi. It's great to be here. And yes, I do have a lot to say. Data use and protection has dominated compliance, and it's only going to get more interesting.
Yes, it is going to get a lot more interesting. Before we dive into the new changes, let's hear from all of you with our first poll question. And it's a really, really good question. Are you ready for DUAA? Are you ready for the Data Use and Access Act? Fully ready with updated policies, training, and procedures. Mostly ready with some updates and more to come. Some progress, but not completely ready. You're aware of the need to get ready, but you didn't start preparing, or you're not sure. So let us know, are you ready for DUAA? Are you fully ready? Are you mostly ready? Have you made some progress, but you're not completely ready? Are you aware of the need to get ready, but you didn't start preparing and you're not sure? So let us know. Give it a couple more seconds to answer the poll. Are you ready for the Data Use and Access Act? I think it's a really good question for us to start with. Okay, really interesting responses. 2% of you, which is very small, are fully ready with updated policies, training, and procedures, and I think that makes sense. 21% of you are mostly ready with some updates, more to come. 29% of you, which is the highest number on the poll answers, have some progress, but you're not completely ready. 22% of you are aware of the need to get ready, but you didn't start preparing. And 26% of you are not sure. So really, really interesting. Nick, what do you think of this spread?
I think it's really interesting. Obviously, it's we were expecting something like that, given that only really just came into force, but enforcement of certain aspects of the Act has already begun, as we'll touch through as we go through the next hour. So it is really important to kind of maybe step up some of your progress on getting things up to date. So I would encourage everyone to kind of speed up the process of and maybe prioritize, but also to make sure that you're putting these things in place as soon as you can.
Yeah, really, really good points. And we're going to get into that over the course of this webinar. Just want to tell everybody here, we've recently published a fantastic new guide to the Data Use and Access Act, and it covers really everything you need to know about the Act and its impact on your organization. A link to the guide is coming up in the chat now. Feel free to click on that link, download the guide. Really, really, really effective guide. Okay, Nick, let's get started by diving into the details. This is clearly a milestone for data protection. What exactly has changed with the DUA coming into effect?
Great question, Naomi, and it actually is quite a lot. So, government passed the Data Use and Access Act back in June, and it's being implemented in phases. But the initial phase began on August 20th, so just last month. That triggered 4 big shifts that compliance teams should know about right away.
Okay, so let's take them one by one.
So the first is that the courts now have a new role in subject access disputes. So up until now, if an organization had refused a subject access request, like for example, saying, certain data was exempt or it was too sensitive to release, the dispute would often drag on, and then the court had to rely on just arguments from either side without ever actually seeing the actual data. But now the court itself can inspect that withheld data directly.
Wow. Okay, so just to be clear, the individual still doesn't get to see the data until the court makes a ruling?
That's right. So the data subject and their lawyers most likely can't access it until the judge decides they're entitled to it. So that will protect the organization from from exposing sensitive material prematurely. But it also means that you as the organization might need to hand over that data to the court if it does get to court. So it can raise the stakes for internal procedures because you want to have a clear and secure way to assess whether that data should have been released or not before you have to, send it to the court.
Wow. So that sounds like a real game changer for litigation strategy. And Alyssa, can you tell us about the second change?
Yeah, of course. So the second big change is the expansion of the commissioner's role. So instead of looking at privacy and isolation, the commissioner must now balance data protection with wider goals. So that's going to be things like encouraging innovation and competition, safeguarding the public, preventing crime, and ensuring children's data receive special protection. So for organizations, this means that compliance can't really just be about ticking a privacy box anymore because of that strategy shift. And it's going to be more about demonstrating trust and responsibility across the board. So whether you're handling employee records, customer data, or sensitive areas like children's information.
Really interesting. So in practice, does this mean enforcement could look different?
Potentially, yeah. So look, it's not going to happen overnight, but when the ICO, or rather the new Information Commission, investigates, they'll now be weighing public trust and confidence as an explicit duty. So that means when you're drafting DPIAs or privacy notices, referencing transparency and public trust is not going to be just best practice anymore. It is aligned with the commissioner's statutory objectives.
So that's really interesting, and thank you. And that brings us to the third shift that you referenced, which is the creation of the Information Commission. What's going on there?
Yeah, exactly. So the process towards the formal reconstitution of the ICO is going to be shifting towards the Information Commission, and that's starting now. So this marks a structural shift away from a single commissioner model that we've had for decades. John Edwards, the current Information Commissioner, he's automatically going to become the chair. And in the coming months, we're going to see several non-executive board members start to be appointed.
So the powers haven't actually transferred yet.
Right. So the enforcement powers are still with the ICO as we know it, but the first step towards a board level regulator is happening. And for organizations, it means we should expect more formal governance structures, strategy publications, KPIs, and decisions made collectively by a board. So think of the ICO evolving into something more like Ofcom or the FCA.
Wow. So that's a big shift. And finally, Nick, let's talk about PECR. I know the timelines there are changing.
Yeah, this is a really, really important one for marketing and communications teams. So under the Privacy and Electronic Communications Regulations, or PECR, you now have to notify the regulator of a personal data breach within 72 hours and not just without undue delay as it was previously. So that now aligns PECR breaches with UK GDPR timelines.
Wow. So in other words, if my company's email marketing system suffers a breach, the countdown starts immediately?
Yeah, that's absolutely right. And 72 hours can go by really fast. So if you don't already have, rapid escalation channels from IT to legal to your DPO, you really want to make sure you have them now. The change is going to put pressure on people like breach response teams because the regulators will expect clockwork efficiency when it comes to reporting these breaches.
Wow. Okay, so that's really intense. And the courts can now inspect withheld SAR data. The commissioner has new duties. The Information Commission has been born, and PECR breach reporting just got a hard 72-hour clock. That's a lot for compliance teams to absorb in one day. What's the takeaway here for UK organizations?
So I think really now is the time to begin updating those processes immediately. That means incident responses, SAR handling, and regulator engagement, because the landscape has shifted in those last few weeks since the DUAA began its implementation journey. So I think those are the priorities to work on.
That makes sense. And Alyssa, if you were advising a board today, what would be your top action point?
I would say first, treat data accuracy as risk management, not simple admin. So you should be running regular audits on addresses, contact details, and system integrity. Most breaches in this category aren't going to be crazy, sophisticated hacks, but rather clerical errors or database errors, and fixing those proactively can save a lot of litigation pain.
Yeah, that makes a lot of mistake. That makes a lot of sense. And speaking of litigation, we're going to discuss another big development recently that impacts breach response protocols, and that is the Court of Appeals ruling in Farley versus Paymaster. But first, let's just get to another poll question. And we really want to hear from everyone here. Which area of the DUA do you anticipate will be the biggest challenge for your organization? Is it meeting the new 72-hour PECR breach notification deadline? Is it handling DSARs under the new court inspection powers? Understanding the Information Commission's expanded duties and oversight? Managing risks of litigation and group claims? Or updating governance, training, and vendor management? Which area of the DUA do you anticipate will be the biggest challenge for your organization? And if there's something else, let us know in the chat. Or if you have more than one challenge, let us know about it in the chat. We want to hear from you. So let us know, which area of the DUA do you anticipate will be the biggest challenge for your organization? The 72-hour PECR breach notification deadline, handling DSARs under the new court inspection powers, understanding the Information Commission's expanded duties and oversight, managing risks of litigation and group claims, or updating governance, training, and vendor management. Or again, I see people are popping into the chat, other challenges, or if they have more than one. So we really want to hear from you. Let us know. Because there are opportunities, but there are a lot of challenges here. We'll keep it open a couple more seconds. We want to hear from you. Okay, really interesting how this broke down. 16% of you say that the new 72-hour PECR breach notification deadline you anticipate will be your biggest challenge under DUA. 12% say handling DSARs. 15% say understanding the Information Commission's expanded duties and oversight will be your biggest challenge. 10% say managing risks of litigation and group claims. And really interesting, nearly half of you, 47%, say that updating governance, training, and vendor management you anticipate is your biggest challenge. So that's really, really interesting. Nick, I see, first of all, let us know in the chat any other challenges. We're still looking at the chat, and really interesting results. Nick, you have some questions that have come in. Do you want to get to those?
Yes, we do. We have a really interesting question that come in. Does the 72-hour deadline include weekends and holidays? So yes, it does. So you may have to be working over a 3-day weekend if something comes in, late on a Friday. That's 72 hours. Another question was around relying on legal professional privilege for SARs and whether or not that's a pre-existing right to go to court, and how does that have to be updated. So I'll just say you don't have to tell the request that you can apply to court, because that right is there and is not going to be triggered by the wording or not. The ICO, however, does expect that if you're relying on an exemption like legal professional privilege, you should explain the exemption and explain how it's been applied and which exemption. You don't have to disclose, obviously, that privileged content. You don't have to include boilerplate text about the right to apply to court. You can if you wish, but you just want to be very clear about the exemption that you're relying on.
Thank you. Those are great questions and really, really helpful responses. And Alyssa, speaking of managing challenges with DUA, this is a great point to highlight our data compliance solution.
Absolutely. So the Data Use and Access Act is all about setting new rules for how organizations collect, share, and use data. And we know that that can quickly get complicated, as we saw in the poll. And that's exactly where Omnitrack's GDPR register can make life a lot easier. So Omnitrack's GDPR suite is already built with the latest regulations in mind, including DUA. So instead of juggling spreadsheets, chasing approvals over email, and then keeping all of those stakeholders up to date, you've got one central platform, and it does all of that heavy lifting for you. You can collect data seamlessly from across the business. You can automate workflows and approvals so that nothing gets missed, and generate a lot of audit-ready reports at the click of a button, which, as we discussed earlier, is going to be really critical. And all of this is important not just for ease of use, because you'll be showing regulators and clients and partners across the organization, but you also want to be able to show that your organization takes data use seriously and you're equipped to keep pace as those rules change.
Wow, thank you. That's really, really, really helpful. And a link to our one-pager and use case study about Omnitrack's GDPR suite is coming up in the chat now. You can click on that to download it. Really, really effective explanation of how Omnitrack can help you managing DUA and the challenges that we had discussed. Okay, Nick, let's get back to the litigation we had said we would discuss. So not only have we had DUA come into our lives now, but there are some new court cases which could also kind of change the rules of the game. Can you walk us through what happened in the Farley versus Paymaster ruling?
Yeah, this was a really significant case. It involved over 750 pension benefit statements for Sussex police officers that were sent to outdated addresses. And more than 450 of these officers then brought claims saying that they'd suffered distress, fear of misuse of their data, and in some cases even psychiatric injury because of it. Now, the High Court had decided before that unless they could prove someone actually had opened that envelope and saw that data, the officers didn't really have a case. And then most of these claims have been struck out. But then the Court of Appeal overturned that High Court case in a landmark judgment, and they said 4 big things in this case. First off, that unlawful processing is enough. Just the fact of sending data to the wrong place counts as a breach, even if no third party actually read it. Second, there's no seriousness threshold, meaning that you don't actually have to show harm was serious. Even some just minor distress can potentially trigger compensation. The third is a fear of misuse, and just the fear of someone misusing that data counts for a court case. And if your data goes astray and you have a reasonable fear that it might be misused, that can itself qualify as a damage. And finally, the low value claims cannot be dismissed wholesale, which is what happened in this case before. Courts can't just strike out hundreds of small claims because they're small. Those claims need to be managed proportionally and dealt with properly.
Wow. So that really lowers the bar for claimants, doesn't it, Alyssa?
It does. So this could potentially open the floodgates to group action. So think about it, Naomi. Even small everyday mistakes like emailing the wrong distribution list or using an outdated address could now spark claims. Organizations can't just shrug those off as just, a minor error anymore. And the timing can't be more striking. So just as DUA has tightened breach reporting, giving you only 72 hours to notify under PECR, The courts are simultaneously making it easier for claimants to sue. So that's double exposure, faster reporting to regulators, plus more fertile grounds for litigation.
Wow. Yeah, the timing does seem quite apt. And it seems like the old defense of nobody actually saw the data, so it didn't hurt anybody, that's off the table.
It's completely gone. So the Court of Appeals made it very clear that disclosure isn't the test. It's the act of unlawful processing itself. So no one opened the envelope won't save you anymore.
And that also means that accuracy and record keeping as well become even more critical. You really have to know exactly where your data is, ensure things like addresses and contact details are always kept up to date and deleted if they're wrong, and then be able to show your audit trail throughout that whole process. That's what's going to protect you much better in court, not arguments about whether the breach was trivial or not.
Right. That makes a lot of sense. Like in practice, you're both saying that organizations are now looking at more litigation risk, more group claims, and less room to argue technicalities. That's kind of a tough new reality.
Yeah, it is, which is why I'd say don't dismiss the small stuff. A 250-pound claim sounds really minor, but when multiplied by hundreds of people in a class action, it becomes very costly very fast.
Yeah, absolutely. And like Alyssa said, document everything. If you can show the regulator and the courts, if it gets there, that you had processes, you had training and audit trails in place, you will be in a much stronger defensive position.
Wow, these are really, really excellent points. Don't underestimate the small incidents, an email error, a mismailed letter, a sloppy update in HR data. All of those actually now carry weight. The new reality is that compliance is only credible if it's lived out in day-to-day operations, not just in policies on paper. This is a great point for our third poll question, and we really want to hear from everyone. Question is, what do you see as your organization's biggest data protection risks? Is it DSAR disputes and court involvement, data accuracy and record-keeping errors, phishing and hacking, human error mistakes, breach reporting failures within 72 hours, or something else? And tell us about it in the chat. We really want to hear. What do you see as your organization's biggest data protection risks? DSAR disputes and court involvement, data accuracy and record-keeping errors, phishing and hacking, human error mistakes, breach reporting failures within 72 hours, or something else? What do you see as your organization's biggest data protection risks? Couple more seconds. We'll keep the poll open. Okay. Very interesting again. Only 2% of you feel that DSAR disputes and court involvement is your organization's biggest data protection risk. 25% of you think data accuracy and record-keeping errors are where your biggest risks lie. 12% say phishing and hacking, and not surprisingly, 56% of you, over half, say human error and mistakes. 4% say breach reporting failures within 72 hours, and 1% of you say something else. So we want to hear from you in the chat, that 1%. What else? What else is your organization's biggest risks? Nick, we have a few more questions that have come in. Do you want to get to them?
Yeah, absolutely. So we're having some great questions in here, and please do keep putting them in. If we don't get to them all today, we will get back to you on the blog and by email. We had one question on, if you rely on employees keeping addresses and personal details up to date, who's responsible if the address details are incorrect? I believe that it would still ultimately be you as a data processor, you as a company. So if you're sending out, for instance, pay slips and someone hasn't updated their address, then it could be you're still on the line for that potentially, unless you can show that you gave them, repeated warnings and opportunities to update their addresses. And that's why regular reminders and regular kind of requests to people to make sure that they've updated their contact details and that they've read that, they've received that, because it might still ultimately rely on you as a processor holding onto that data. With interesting question as well about damages and potential for damages if it goes to somewhere like court. So punitive damages in the UK are relatively rare. Usually what happens under UK or English and Welsh law at least is that the damages will be given to kind of put the claimant back in the position that they would have been in, and maybe a little bit more for distress. The bigger risk, though, is for the fines against you as a company from the ICO, from the Information Commission, because those fines can obviously go up to 4%, potentially £17.5 million if something goes wrong. So that's more of your bigger risk, because if there's been a breach or something is exposed, and if there's been, a case with an individual that you need to get right, that itself could, lead to an ICO investigation looking at what went wrong, and that's when you might end up with some of those big headline fines. So that's more of the risk.
Wow, thank you for that. Really, really excellent questions and great response, Nick. Thank you. And just to let everyone here know, if you want to help your organization manage your data protection risks, we have a data protection policy template that a link to it is coming up in the chat now. It's a really, really helpful tool to ensure your data protection policy is communicated across your organization. If you have a policy, it's really helpful that everyone has access to it, knows about it. Our policy template is a really effective way to do that. And the link is coming up in the chat now. And so, okay, we've talked about some of these changes. And in the UK, we've seen talk of turning back some of the data protection restrictions we've had since GDPR, whereas it looks like DUAA is adding to the compliance burden. Nick, where does DUAA sit within the changes to data protection we're seeing in the EU also?
So DUAA is kind of doing both. It both amends UK GDPR rules, but it also adds to those rules we have in the UK. You can think of the DUAA as a UK kind of deliberately carving its own path on data protection. On the one hand, some rules are looser. Automated decision-making is less restricted unless it involves special category data. That is a kind of win for the company side. And certain recognized legitimate interests like fraud prevention or safeguarding don't need the balancing test that we had to do under GDPR. But on the other hand, enforcement is much tougher. PECR fines, that's the Privacy and Electronic Communication Regulation, so email marketing, phone marketing, that sort of thing, they now match GDPR levels, meaning fines could go up to £17.5 million or 4% of global turnover, whichever is higher. And the Information Commission itself will have new interview powers, and that will have criminal liability for misleading statements. So if the commission comes to investigate and they interview people and they lie, then there could be criminal liability for those individuals also. And the regulator is moving to that board-led structure, as Alyssa touched on earlier, which will make it much more proactive in terms of launching investigations.
Wow. So DUAA is doing a lot of different things and changes. And how should we feel about that?
Yeah, so you can look at the UK data protection regime now as having three key elements, three layers. You've got UK GDPR from 2018 and the Data Protection Act from 2018. And now this third layer, this Data Use and Access Act. So it's become this tripartite system instead of a dual system we had until now, where we just had the DPA 2018 and UK GDPR. So many organizations will feel that DUAA is a new addition to the compliance regime, not just a minor amendment. And I think it's really also critical to remember DUAA also represents a strategic opportunity for a lot of companies.
Okay, that's interesting because we usually talk about these reforms as risks, not opportunities. Can you expand on that?
Yeah, so under GDPR, the conversation often started with fears of fines, but DUAA is a little bit different because it does give organizations more of a leeway and more chance to embed trust, transparency, and accountability as real differentiators for their organization. And businesses that do act early can not only reduce that regulatory exposure, but also strengthen trust with customers and position themselves as a leader in responsible innovation and doing different things with data. data. So think of DUAA more like a framework that rewards organizations who invest in things like rethinking their subject access request workflows so they're faster, more user-friendly, reviewing automated decision-making tools to make sure they're fair, they're explainable, auditing cookies and marketing practices to make sure you don't have those weak consent mechanisms, and updating governance, things like records of processing, DPIAs, training, all of that so it reflects today's rules and also the direction the company might go in tomorrow.
Interesting. So instead of waiting for every detail of secondary legislation, companies, it sounds like, should move now.
I think there's a lot of space to start the process now because we do know the direction of travel, and waiting until June 2026 when everything should have been phased in, you're already going to be behind. And I think the smarter move is to really begin the process now and speed up that process if you already began of reviewing, refreshing, and future-proofing all of your data practices, particularly around things like subject access requests, automated decision-making, and of course, marketing communications.
Wow. It makes a lot of sense. And Alyssa, it sounds like a balancing act with more flexibility in some areas, but much higher risk in others.
I'd agree with that. And I'd add the real danger here lies in the gray zone. So DUAA introduces concepts like compatible further processing and smart data schemes, but it doesn't really spell out every detail just yet. And so that's where disputes, test cases, and the ICO investigations are really going to land first. So take smart data, for example. On paper, it's about letting customers and third parties access things like usage or pricing data similar to open banking. But what happens when a business wrongly refuses a request or accidentally discloses too much? You're looking at maybe civil claims, maybe enforcement, or both, or automated decision-making. So the law is now a bit more permissive, but that doesn't necessarily protect you from discrimination claims under the Equality Act if your algorithm is biased. So the guardrails may be lighter, but potentially the litigation risks are going to be a bit sharper.
Okay. So compliance teams can't just breathe a sigh of relief and say, okay, great, less red tape.
Exactly. So compliance is going to be judged more and more on how well your processes hold up under stress. So whether that's an ICO compliance interview in the middle of a subject access dispute, or even potentially in the court of public opinion after a breach.
Yeah, and also don't forget the impact of reputational risk here. I saw a comment on the chat, which was really interesting, saying there's a potential that this might be overhyped because the ICO itself has said that there's not that much for organizations to do. I would say that that is not fully accurate in terms of the broader array of risks that we do have to look at, because reputational risk can be, the sort of thing we can't really quantify, but if it happens, it's something we don't want to be involved in. And the issue is campaign groups are seizing on DUAA's test cases to shape that narrative a bit more. We see that in the EU happening constantly with a number of campaign groups really pushing GDPR to its limit across the EU. So if your company mishandles, a smart data request or has a sloppy process, it's not really just the ICO who you have to worry about. It's a potential for headlines as well.
Such a good point. So if the GDPR was about building the rules of the game, DUAA is about testing how well you actually play.
Yeah, exactly. That's exactly right.
And Alyssa, do you see this opportunity side of DUAA like Nick mentioned before?
Yeah, I love that framing. So I think it comes down to credibility and resilience. Organizations that treat DUAA as a tick box exercise are going to struggle when they face real world tests, whether that's a regulator or a group claim or just customer scrutiny, as Nick was mentioning just now. But if you treat DUAA as a catalyst for smarter strategies, you can gain a competitive advantage. That means you should do things like scenario testing, like running drills on complex data subject access requests or admin challenges like we've been discussing. Also supply chain reviews. So like checking vendors and processes meet the new standards. That was when we did that earlier poll, the biggest risk area. And of course, employee training. So making sure everyone from marketing to HR to customer services, they know their role under DUAA. People matter. And if they understand these policies, they can be a big asset, not a big risk. So you finally need board level buy-in, treating privacy and data ethics as a strategic priority. So this is not just compliance admin. Those are the organizations that are really going to thrive under DUA because they'll be trusted by customers, by partners, and ultimately by the regulators.
Right. Thank you for that. And you're saying DUA isn't just about avoiding penalties. It's about actually embedding the data protection into the actual DNA of your organization.
Exactly. So it's about moving first, thinking deeply, and showing that compliance is a part of your brand's integrity. And that's where the winners are going to emerge. The ones who use DUA to build smarter, more ethical, and more resilient data practices.
Thank you. Those are really excellent points. Thank you. And let's get to another poll question. And I think this is another really relevant question for where we're at in the webinar. How do you view DUA overall? What do you think of DUA overall? Mostly positive with more opportunities like we discussed here for innovation and trust building, kind of a mix of risks and opportunities, mostly challenging due to heavier compliance burdens and litigation risk. It's too early to tell, depends on how enforcement plays out, or minimal impact, doesn't change much for us at all. And let us know in the chat what specifically you're thinking of. How do you view DUA overall? Mostly positive, more opportunities for innovation, trust building, a mix of risks and opportunities, mostly challenging due to the heavier compliance burdens and litigation risks. Too early to tell, depends on enforcement, or minimal impact. Doesn't change much for your organization. Pop in the chat. Let us know specifically what you're thinking. How do you view DUA overall? So interesting. 7% of you feel mostly positive with more opportunities for innovation and trust building. 26% of you see it as a mix of risks and opportunity. 20% of you feel it's mostly challenging. The heavier compliance burdens, the litigation risk makes it more challenging. 34% of you say it's too early to tell. It really depends how enforcement plays out. And 14% of you say minimal impact doesn't really change. So very, very interesting results. Alyssa, Nick, what do you think of these results? And how do you see it?
Feels very honest.
Yeah, absolutely. I actually think ultimately it's going to be mostly positive with a lot more opportunities for innovation once all the bits and pieces get working. I think what's really critical is going to be this transformation from the ICO to Information Commission. The ICO, to put it mildly, hasn't really been that helpful in recent years. There's just been not a lot of things that are useful coming out of it. And in some ways it's because it's winding down and we're going to get something different at the end of it. And one of the biggest things that the Information Commission will be doing is focusing on encouraging growth and supporting different ways to use data. That is the ultimate goal of the legislation. I think we will see that eventually. And some of the people in the comments there said, like in the charity sector, the opportunities with a soft opt-in can be a bit of an opportunity as well as a risk, but these are the kind of minor-ish changes like soft opt-in, like the changes to recognize legitimate interest, that ultimately, once you're able to really get a handle on what DUA can do for your own organization, it'll be different for every company. That's where you might be able to spot those gaps, spot the differences, and then take advantage of those potential opportunities. And that's why we're saying get ahead of it now, because if you understand where your organization fits and sits with all of that, then you'll be able to identify more of those opportunities more quickly. Such
a great point. That really is. That's great reason why it's important to get ahead of it now. And to help you better understand the Data Use and Access Act, kind of the timeline and implementation, we created this DUA implementation fact sheet. It's an incredibly useful document that will ensure you can keep track of the process. A link to the fact sheet is coming up in the chat now. You are going to want to download this. This fact sheet kind of has everything, one pager. You'll be able to really get a sense of the phases, the process. Really, really helpful. Okay, let's turn this into some concrete advice, Nick. What should organizations prioritize in the short and medium term if they want to treat DUA as the opportunity that you discussed and not as a headache, which quite a few people on the webinar said that that's how they see it.
Yeah, absolutely. So I think this is what I'd recommend to start with. First, in the immediate term this week, if you haven't done it so far, look at your subject access request procedures and incident response plans for that new 72-hour rule. Then kind of broadly in this quarter, look at how your cookies work, look at how consent works, and potentially look at refreshing the privacy notices you have and put in place some of that DUA specific training into different staff programs. So maybe start with marketing, maybe start with HR or AI and those sorts of kind of areas where there might be the most opportunities. I think by the end of this year, it's a good idea to review vendor contracts and then supply chain compliance so that your third parties don't become the weakest link in this area. And then into next year, looking at maybe building some scenario testing, look at maybe getting the board to do kind of a examination of different things, governance testing, rehearse. How would you justify, an automated decision? How would you handle, an interview if something went wrong?
Great advice. And Alyssa, anything you'd want to add?
Firstly, I'd say those are all really good points. I'd add a few things. So first, be ready for litigation. So with the Farley case lowering the bar for claims, you need to document decisions, update insurance coverage potentially, and set up fast track resolution channels to stop complaints turning into lawsuits. Think about fixing any clerical errors before they become a litigation magnet. And next, to work on board engagement, brief directors on DUA and its actual strategic issues. Ensure that we're framing this is not just compliance admin. And finally, to make sure that training goes beyond just compliance teams, but it reaches everyone who touches data. We said this earlier, but it affects everyone from your HR teams to your marketing teams, and even frontline staff who handle data, and they might need to know the basics of DUA. A single misstep at an operational level can now cascade into litigation. So an early investment into process and training now can hopefully save you from expensive disputes later on down the road.
Oh, such an important point. And it sounds like if you invest early, you won't just survive DUA, you might actually thrive under it. So our final poll question for the day: what will your organization's top DUA compliance priority be over the next 6 months? Do you plan on updating SAR and incident response playbooks, training staff across the business, reviewing vendor contracts and supply chain compliance, preparing for regulator engagement and litigation risk, board level engagement and strategic buy-in, or something else? And do let us know in the chat. What will be your organization's top DUA compliance priority over the next 6 months? What are you planning? Again, updating SCR and incident response playbooks, training staff across the business, like Alyssa said, so important. Reviewing vendor contracts and supply chain compliance, preparing for regulatory engagement and litigation risk, board level engagement, strategic buy-in, or something else. Let us know in the chat. And if it is all of the above, that's good. I just saw someone wrote that, and it could be that is your priority, all of it. Few people are writing that. Let us know. What is your top DUA compliance priority? Give a couple more seconds. Our final poll question. We want to hear from you. Okay, really, really interesting. 25% of you say updating SAR and incident response playbooks will be your DUA compliance priority. 39% of you, that's the biggest chunk, say training staff across the business. I think that's going to make Alyssa happy. 9% say reviewing vendor contracts and supply chain compliance. 5% say preparing for regulatory engagement and litigation risk. 19% say board level engagement, strategic buy-in, and 3% of you say something else. And really let us know in the chat what that something else is. Want to hear. Really, really interesting the way it's spread out, what you plan on doing for your DUA compliance. And Nick, I know you have some more interesting questions that came in, and you have some more answers for us.
Yeah, definitely. So a few more we've seen in someone asked, if someone makes a genuine error, so maybe they were in training, does this mean they could get blamed and will they be liable personally? So in most cases, the answer is no. An individual won't personally be liable if there's a genuine error that's been made. Regulators tend to look at systems, culture, and supervision. But on the other hand, there are potentially criminal elements depending on what happened. So someone's stealing data and then potentially selling that. We've seen court cases happen. We've seen people go to prison for that recently. So if the error is, done in good faith, it's highly likely for the individual to be blamed in that sense of legal liability. But the employer does need to catch it and correct it, and then have systems in place so that the person, can't all of a sudden, delete every person's details or send emails out to everyone. So it is about processes. Another question we had in is, are there circumstances in which DUA could have extraterritorial reach outside the UK? The answer is potentially, depending on the context. So if, a company offers goods or services to people in the UK or monitors behavior of people in the UK and they're based outside of the UK, then there would be that extraterritoriality and they would be kind of covered. So, US tech firm tracking UK users, that will be within scope, or a non-UK company that's processing, UK data could also be caught out. Issue is going to be enforcement. How do you enforce something when a company is based, overseas? And it's not like EU GDPR where there's, a one-stop shop framework. So enforcement overseas will be more ad hoc. And if a company is in, the Bahamas or something very hard to catch, then it's going to be more difficult. But in general, yes, if you're outside the UK, but you do process UK personal data, then DUAA changes will come along and be relevant as well.
Wow, that's great. Really, really excellent questions. Keep popping your questions into the chat. Really, really helpful for everybody. And just so everyone here knows, we developed a DUA compliance checklist that can be really helpful for any organization in managing their DUA compliance, and it involves each of the practical steps you can take right away in a really easy to use checklist. And the link to the checklist is coming up now in the chat. Download it. Really, really helpful. Okay, Alyssa, one of the things you mentioned, and one of the things that came up in the poll, is how important training is for all staff in an organization to really understand how to handle data. Now, we know you're the director of courses at VinciWorks. Can you tell a little bit about how you provide this training, especially in light of DUA?
Absolutely, I'd love to. So when it comes to DUA, policies and tech aren't really going to save you if your staff don't know about them or know what to do in practice. And the truth is that most data breaches aren't sophisticated hackers, even though that can definitely be a factor, but most data breaches come down to simple human error. And that's why training is so critical. And so with our courses, we try to cut through all of the legal jargon, and I'm a bit biased, but I do think we do a really good job of showing staff exactly how to handle data confidently, responsibly, and importantly, in light of the new rules. And I know we keep saying this, but it's really not just about avoiding fines. It's also about protecting trust, unlocking opportunities, and proving to regulators that you take compliance seriously.
Yeah, no, it's clear that that's so important.
It is. And the first thing I'll say about our courses is that all of our data protection courses are updated in light of DUA. And that means that if you use any of our suite of courses, your staff will be updated on how to handle data in line with DUA. The other story here is that we have, in addition to our standard data protection courses, rolled out a dedicated course on DUA. We cover everything from UK GDPR and DUA and how they work together, to the roles and responsibilities of authorities, which can get very confusing, to importantly, who needs to act and when. We also cover transferring data internationally, which can sometimes be complicated, and we have clear explanations for each of the elements of the new act. So that should be very helpful for staff. And of course, we also have a knowledge check. So after that training, if you want to check in with your staff to ensure that they understand the material afterwards, that they really get it.
That's great. That's great. And it's a 5-minute knowledge check, but it's really effective. I did it. It's great to really see that your staff actually knows what they learned.
Exactly.
So thank you. That was really, really impressive. And of course, if you're interested in learning more about VinciWorks online training course on DUA and data privacy, write data in the chat now and someone will be in touch. So let's get to a few questions we got from you. And a lot of these questions are the questions you wrote to us when you registered. So, and we got a lot of questions in. If we don't get to all your questions here, download our DUA FAQ guide that we put together for you. And these are all the questions we received from you when you all signed up for the webinar. And so if you asked a question, it is going to be in this guide. So really, really worth downloading this guide. A link to it, to the DUA FAQ guide, is coming up in the chat now. And thank you so much for the questions you've asked us before, that you asked us during the webinar. And we're going to get a blog up on the website after the webinar covering any of the questions we didn't get to today. So really be sure to keep an eye out for that. And there are other questions we've had in, and want to get a chance to answer some of the questions in the couple minutes we have left. So Nick, let's start with you. One of the questions, can I get some practical guidance on ensuring compliance with DUA? To what extent can existing processes and procedures be used? Nick, what do you think of that?
It's a really good one. And the good news also is you don't need to start from scratch for DUAA compliance. So think of GDPR and the Data Protection Act 2018 as your foundation. So most of what you already have in place still applies. What you really need to now do is layer DUA on top and then refresh certain areas. So look at those subject access request workflows. The rules on data subject rights have shifted slightly as well. So you want to check your internal playbooks, update templates, make sure staff know how to handle those requests under the new rules. Second, those breach response procedures and that 72-hour reporting window is really, really critical. That is where a lot of people will end up kind of falling. So really test those escalation routes. If a breach happens, would they get flagged? Would they get assessed quickly enough? Maybe run a tabletop exercise. That can be a great thing to do to just test all those procedures. Review your privacy notices as well, because DUA introduces that new recognized legitimate interest. So if that's a basis you rely on, then you want to update the notice to reflect that. And remember, the ICO still expects transparency, plain language, and clarity as well. And finally, as Alyssa said, don't forget about training, because embedding DUA into your staff training is really critical. It's, I think, less about rebuilding and more about doing a structured, gap check, mapping existing GDPR processes against DUA, identify what's already covered, and then focus your energy on those handful of areas that might need updating. That way you're refining rather than reinventing the whole compliance framework.
Wow, thank you for that. Great question and great answer. Okay, another question that we had in, and Alyssa, I'm going to throw it to you. What do you think is the single biggest risk right now with regard to DUA? Like, what do organizations need to think most about?
I think this straight aligns with that poll question, and I'm going to agree with everyone here. If I had to pinpoint the single biggest risk right now, I'd say it is accuracy. I don't mean that in an abstract sense, but the day-to-day operational mistakes that creep in, that human error element, most of the claims that we're likely to see in the near term aren't going to come from a sophisticated cyber attack or cutting edge AI misuse, but it's going to be very ordinary errors, like sending personal data to the wrong postal address. It's going to be misuse of the to field instead of BCC. It's going to be people holding on to outdated records that should have been deleted years ago. These kinds of mistakes, they sound really simple as I'm saying them and as we've said them throughout this webinar, but they're so common. That's why we're saying them so much. And under DUA, just like GDPR, regulators, they take them really seriously because the impact on individuals can be immediate and very real. And that's why I want to stress that your biggest defense here is clean, well-managed data. If your contact lists are up to date, if you're not holding on to excess information, if your staff are trained to double check before hitting send, you have reduced a huge portion of your risk exposure. The second line of defense is internal audits and spot checks. Don't wait for the ICO or a complaint to expose weakness. Build in regular reviews of your data handling practices, whether that's testing subject access response process, reviewing access controls, or simply checking that your deletion policies are actually being followed by staff. It doesn't have to be resource heavy. Small routine audits can help everyone stay sharp. They can show regulators that you're taking compliance seriously. So accuracy might sound really basic, but in practice, I think that's where most organizations are likely to stumble. So if you can get that right, you'll prevent the majority of avoidable claims before they even get started.
Wow, excellent. Thank you. Thank you for that response and great question. So Nick, I think this is the final question we'll get to today. What if we're talking about a smaller organization with limited resources? Like, what can they do?
Yeah, it's a really good one because, a lot of smaller organizations will be looking at DUAA and think, well, we don't have, the budget or the teams to handle this. But honestly, compliance doesn't need to be that complicated or expensive. Focus on these three essential elements, and I think you'll cover most of your immediate risk areas. The first, as we said, is incident response, having a clear process for recognizing a breach and escalating it. Who's going to get the call? Who's going to make the call if needed to? Because that 72-hour reporting window, there is a ticking clock and things need to happen. Even a simple flow chart showing who gets called, who makes the decision, how it's logged, all of that can make a big difference. And the second thing is around this subject access request handling. People are exercising their rights more than ever. And usually what happens is the more this is in the news, the more people want to exercise their rights. And you need to be ready for that. Also, what happens if it's ex-employees? What happens if it's vendors? You need to have documented playbooks. Who owns the request? How will you track the timeline? What templates will you use for responses? What happens if you want to say no to a response? How are you going to manage all of that? That's why we have our OmniTrack system, which we mentioned earlier, which is a really, really good way to invest in a small amount of technology that can help tomorrow's compliance. But it doesn't really matter if you use OmniTrack or any other system. The issue is having a system in place. That's really going to help. And then the last thing is the risk is sounding like a broken record, obviously, training. Every staff member who touches personal data should really know the basics of DUAA, what counts as personal data, what to do if something goes wrong, and why accuracy, as Alyssa said, really, really matters. Just short sessions, even sometimes an e-learning module is done annually. That can be enough to build confidence in people and then prevent that kind of error. As we saw, most people are worried about human error, and that really is where the biggest risks are. And training really is our best mitigation against human error. And I think if you get these things right, you're going to be a long way down the road to being fully compliant. They're small steps, but they can end up punching quite more above their weight in protecting your organization and making sure that you can show regulators, if something bad happens, that you've taken compliance really seriously.
Wow, excellent. Thank you for that response. Really, really helpful. And I think today's message in general was really clear. DUAA is here. Farley versus Paymaster raises the stakes, and compliance is no longer just about paperwork. It's about practice. It's about resilience. It's about trust. And if you treat DUAA as just a tick box exercise, you're constantly going to be on the back foot. But if you treat it as a strategic opportunity, refreshing your DSARs, auditing automated decisions, cleaning up cookies and marketing, engaging your board, and training your people, you'll not only stay compliant, but you might also thrive. So I want to thank our panelists today, Nick Henderson-Mayo and Elisa Retzon, for their insights. And thank you to everyone here for joining us. Really, really appreciate you coming. We really look forward to seeing you again here soon.